Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and I'm the owner of Ashburr, where we specialize in Medicaid compliant annuities. Today, we're going to be talking about, it's really a continuation of our March webinar. This is part 2, gifting and annuity plans with illiquid assets. And I'm happy to have attorney Mark Munson with us this morning as well. He co-presented our March webinar, and I'm very excited that he was able to set aside the time to be with us today and help co-present our April webinar as well. Mark is a certified elder law attorney and practices primarily in the state of Wisconsin and is able to help co-counsel with other attorneys that are doing elder law and estate planning as well. Again, my name is Amber Hines, and I'm the owner of Ashburr. I have spent the last 15 plus years working with elder law and estate planning attorneys across the country on Medicaid compliant annuities for their clients. I am licensed in all states and hold my Series 65 license with FINRA. And I really created Ashburr to assist advisors as well as attorneys with pre-planning solutions such as hybrid long-term care insurance, as well as crisis planning strategies, primarily by way of a Medicaid compliant annuity or prepaid funeral policies that would be considered exempt for Medicaid qualification purposes. Some of the ways that my company can help you and your clients is we offer complimentary case analysis, meaning that we will assist to help in determining the optimal amount to purchase an annuity for, the optimal term of the annuity, and which assets your clients may consider annuitizing, which is one of the topics that we're going to be touching on today. When your clients have assets that are not considered to be liquid assets that are just sitting in the bank in a checking or a savings account, we're going to be talking about the different options that your clients would have with assets that are considered to be illiquid. We offer assistance from the beginning to the end of a case, meaning that we will provide quotes for your clients to consider when purchasing a Medicaid compliant annuity. We assist with the funding of the annuity if your clients have existing IRAs or life insurance, non-qualified annuities, things of that nature. We can help to do direct transfers of those types of assets into a Medicaid compliant annuity. And then also we will assist with the death claim process if that would become necessary. In most cases, with the state being the primary beneficiary on a lot of these annuity contracts, we would reach out to the state Medicaid agency, obtain a clearance letter or the amount that they have provided in Medicaid on behalf of the client, and then work with the secondary beneficiaries to help close out that claim with the insurance company that issued the Medicaid compliant contract. We do work with A-rated insurance carriers, and we offer top-notch customer service as far as getting back to our clients and the attorneys that we work with within a 24-hour time frame. So last month we talked about an individual that is in a nursing home that would be applying for Medicaid when we do not have a spouse involved. And the primary strategy that we focused on last month was the gift and annuity strategy, where a client was gifting assets out of their name and then using cash assets to purchase a Medicaid compliant annuity to pay through a penalty period. Our scenario last month was dealing with all cash assets. Mary had around $205,000 that was just sitting in a checking or a savings account, which is rarely the case. So we're going to start first by reviewing the case facts that we talked about last month and the results of that plan, and then we'll get into how to deal with a different fact scenario if Mary has illiquid assets and not money just sitting in the bank. So our case study from last month was Mary, who was 80 years of age, and after living at home with dementia for years, she is now in need of nursing home care. Her family feels that she could live for another 5 years in this sort of supported care environment. Her total countable assets were around $205,000. This was all after tax dollars or cash that was in the bank. She had around $2,000 of income each month from Social Security and pension, and then she was spending $10,000 per month on her nursing home costs. The economic results of the plan that we went through last month was that Mary was able to make a gift of around $213,000, which was causing her to be ineligible for Medicaid or needing to privately pay for her care for a 12-month period. Mary purchased a Medicaid compliant annuity with the remaining spend down amount, subtracting the $113,000 approximately from the $205,000 that she had of assets, and we determined that she needed to purchase a Medicaid compliant annuity for $92,320.84, which was structured over a time frame of 12 months, and that was generating monthly income of around $97.10 each month that she had an income during that 12-month penalty period. Her monthly income shortfall during the course of the 12-month private pay period was $290 per month, and Mary was found to be eligible for Medicaid in month 13 after she privately paid for the 13-month or the 12-month private pay period. The advantages of this type of plan was that it allowed Mary to gift to her children around $113,000, and this was more than 50% of the total assets of $205,000. Because the gift was all made with after-tax dollars, we really weren't concerned about the income tax consequences of making the gift because it was money that was just sitting in the bank, and we weren't dealing with any retirement assets or non-qualified annuities that we were needing to deal with in order to make this gift of around $113,000. Mary then received Medicaid in month 13. So like I said, in our original example, we assumed that the full spend down amount of $205,000 was all cash. And this is rarely the case, which if any of you have already done gift and annuity strategies for clients, you likely are aware of this, that you're rarely going to run into a case where all of the money is just sitting in the bank and it's a simple answer as to how to deal with the assets in order to implement this type of planning. So today we're going to really be focusing on what if Mary has a spend down amount that consists of real estate, IRAs, non-qualified annuities, life insurance, or other illiquid assets that need to be dealt with in order to qualify for Medicaid. First, we're going to be focusing on real estate, and Mark, I'm going to let you kind of take the lead on this as far as talking about a client's primary residence and other real estate that a client would own.
Sounds good. Thank you, Amber. So when you have someone's home, their primary residence, that certainly clearly is an illiquid asset. So from a Medicaid eligibility standpoint, what are all the things that we want to think about? Well, certainly, we may want to think about the home as being an exempt asset. And what we mean by that from a Medicaid eligibility standpoint is that we may be able to treat the home as being an exempt asset for purposes of receiving Medicaid benefits. We'll talk a little bit more about that in a couple slides. Depending on what the other assets are, we may want to gift the home. If we do gift the home, we want to think about all the considerations involved with doing that, or we may want to liquidate or sell the home so that we reduce the home from being an illiquid asset to being a highly liquid asset, which would be cash. So in terms of the home being an exempt asset, the law, and it's federal law, is pretty clear on this, that as long as the applicant, that's Mary in this case, as long as she or her agent under a power of attorney or a guardian or conservator can express the intent to return home, then the home should be an exempt asset and not counted towards your state's asset amount. I practice primarily in Wisconsin, and we're still stuck at $2,000 being the asset amount. But the home can be excluded or exempted from that $2,000 asset limit as long as we convey in an intent to return to home. Now, one question that comes up from time to time is, does the intent have to be subjective or does it have to be objective? Well, for purposes of the home being an exempt asset, for purposes of Medicaid eligibility, it's really a subjective. Well, I guess I'll be speaking to Wisconsin only, and you want to make sure you understand how your state treats this. But I do think generally, if as long as it's a subjective intent, whether it's realistic or not, that's what's required in order for the home to be exempt for eligibility purposes. However, if objectively, according to doctors, caregivers, healthcare providers, there is no serious ability to return home, then you have to be worried about a Medicaid lien being placed on the home. The only asset that liens can be placed on is the homestead. And you have to be mindful of that. So even if you exempt it, it could have a lien put on it. In addition, if it remains in the client's name and then the client passes away having the home in his or her name, it could then be subject to estate recovery. So while it may be exempt for purposes of eligibility, it will very, very likely not be exempt for purposes of Medicaid estate recovery. So, and then as the slide suggests, if the home is later sold with the net sale proceeds received by the client, we could then look at putting into place a gift and annuity strategy or plan with the proceeds from the sale of the home. So another option may be that we want to gift the home. So if you go back, or if you think about the Mary example, and Mary's got $205,000 of assets, if the home is worth $100,000 and she has cash of $100,000, we then, maybe we'd want to gift the home so that we can get the plan put in place right away and not have to wait for the home to be sold. And so if we gift the home, then as planners, as planning attorneys, we have to be mindful of all the issues that affect our client, our clients. And in this case, if we're going to gift the home, we want to be mindful of both income tax and gift tax. Chances are, if we're working with a client who is looking to become eligible for Medicaid benefits, we're really not going to have to worry too much about gift tax issues. But be mindful of the gift tax issues. More importantly, I think in cases of Medicaid eligibility are the income tax issues. And so there's a couple of income tax issues for us to be aware of. And they all have to deal with the same thing. They have to deal with the gain, the appreciation of the client's home between the time from when they bought it until now. So let's go back to the Mary example. If Mary purchased her home for 50,000 and it's now worth 100,000, there is in that example right now $50,000 of unrealized capital gain. It only becomes realized if we sell it and we transform it from real estate to cash. So in what we want to try to do as planners is to avoid or limit our clients' tax liabilities. Well, in the sense of having a home, if we do this with Mary's home, Mary bought it for 50 and it's now appreciated, it's worth 100,000. If we gift the home to the kids, then the income tax rule that applies here is what's called carryover basis. And the basis is the tax word for cost. It means the same thing. Or purchase price. Basis, cost, purchase price are all synonymous. So what was the purchase price for Mary? It was 50,000. So if that carries over to the kids, what are the kids' purchase price? 50,000. So if this home gets sold by the kids for 100,000, 100,000 minus a purchase price or cost or basis of 50,000 means there's going to be $50,000 worth of gain. And it's not the end of the world. They just have to pay 20%, which would be $10,000 of tax. Well, can we avoid that? And the answer is, if we use a trust and we do some things with the trust, we can avoid that. So if instead of Mary gifting the home to her kids, she gifts the home to a trust, and the trust is drafted in such a way that anything in the trust is not an available asset to Mary, and it's an actual gift that creates a penalty period. The trust can be drafted in a way that for income tax purposes, if the home is sold, we could still get the homeowner's exclusion, excluding the gain, which is section 121 of the Internal Revenue Code. And the homeowner can exclude up to $250,000 of gain. Well, Mary's gain is only 50. So if instead of transferring to the kids, Mary transfers to the right kind of trust, and the trust sells the home, we're still able to get the homeowner's exclusion. The other thing to be mindful of is stepped up basis, stepped up cost, or stepped up purchase price. And whatever words you want to use is fine. It all means the same thing. The concept of stepped up basis is that if someone owns an appreciated asset and they die holding or owning that asset, the purchase price gets increased or stepped up to equal the fair market value on the date of death. So in this example, if Mary never goes to the nursing home, but she dies owning her home, instead of the purchase price being 50,000 for the kids, it gets stepped up and it's going to be a purchase price of 100,000. Well, 100,000 minus 100,000 is zero capital gains. So if you transfer to the kids, you don't preserve stepped up basis. If you transfer to a trust, there is a way, even if it's an irrevocable trust for Medicaid purposes, there's still a way to preserve stepped up basis. So these are the income tax considerations you want to be mindful of when gifting appreciated real estate, including the residence.
Perfect. Mark, we have a quick question here that I wanted to address now, just because it's related to this topic. The question is, if a client does not have capacity and there's no gifting powers in the POA or trust, how do we help the client in this situation? Would a guardianship help, and do judges usually allow gifting?
You're right. Well, you are right on all of this. And let me say that this underscores the importance of having very, very, very good, comprehensive, durable powers of attorney for property and finances. And if your power of attorney is lacking, then your only option is to go to court. But in our experience, courts are loath. Courts generally won't approve a gift. And so, we try our darndest in our practice to have powers of attorney in place before incapacity, because those powers of attorney can not only allow for actions, routine actions to be taken, but they can also allow for planning to occur. In this case, we're talking about Medicaid eligibility planning. And so my experience is that judges are very, 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 very reluctant to allow a client to do Medicaid planning, especially or award under guardianship to do Medicaid planning, especially if there's no documentation anywhere that this is something that they would have otherwise wanted to do, even though it seems like most clients would want to do this and preserve assets for their family members. I think, this is me being a smidge cynical, but I think judges, as being employees of the tax dollar, don't like seeing the tax dollar go to other things other than their salary. But I don't think that's totally it, but I think that's, I think that could always be in the back of their mind. My experience is judges don't like it and they generally won't approve it. So we want to stay out of court and stay out of the way of judges. So focus on your clients having really, really good and broad, comprehensive financial powers of attorney. So, what about if we sell the primary residence? Again, just be mindful of the code section 121 homeowners exclusion, and that exclusion, the basic rules are, as long as the real estate has been the primary residence of the client for 2 or more of the last 5 years, you get the homeowner's exclusion. And it's like I said before, it's up to $250,000. If you're married, it's $500,000. So that is just something to be mindful of for our clients whenever they're gifting or selling their homestead. So what other real estate do our clients have? It runs the gamut. Vacation homes, second homes, cabins, vacant land, rental land, hunting land, timeshares. All of these are examples of other types of real estate assets that our clients can have. And if they are, I always, whenever I'm talking with clients, I use real estate's not like cash. And so it's hard to pay a care home, a nursing home, or assisted living, or even a home care agency with real estate. They want cash. Everybody wants cash. So all of these types of assets in terms of real estate get tricky for us, but they're even more tricky than the homestead because you can't exempt these assets. So what can you do with other assets, other real estate assets? Well, you're really looking at getting them sold so that it is liquid cash that we can do something with, or gifting it. If we're going to gift it, chances are it's probably real estate. What's the purchase price and what's the fair market value? Do we want to preserve something like stepped up basis? So who do we gift it to should be something that we're thinking about. In certain states, you may want to see if listing the real estate for sale buys you some time. In Wisconsin, if we've got real estate other than the homestead, listing that with the realtor, even if it's a little above what the realtor believes is fair market value, means that that real estate doesn't have to be counted towards doing the rest of our planning, which is the spend down, the gift, and the annuity planning.
Okay, perfect. Do you have anything else to add on that, Mark, before I move on to IRAs and other retirement accounts?
Nope, not unless there's any other questions on real estate.
Okay, let me check. Okay, we are good to go then to move on to IRAs and other retirement accounts. The map here that you're seeing on the screen is showing all of the states that are in white that consider retirement accounts or IRAs to be countable assets for Medicaid qualification, which is most of the country, with the exception of the states that are in orange. The states that are in orange are showing states for Medicaid qualification purposes that consider the IRA owned by the Medicaid applicant to be completely exempt, or to be exempt if the IRA is in payout status or the client is receiving their required minimum distribution for IRS purposes. So if we're dealing with an IRA that is considered to be countable for Medicaid qualification purposes, or not just IRAs, but retirement accounts in general, we would have two different options for the retirement accounts if they are considered countable in your state. First, we could consider transferring or rolling over the IRA into an IRA Medicaid compliant annuity to give us additional income to pay through a penalty period. The second option would be to liquidate the retirement account or the IRA and liquidate that, pay the taxes, and then make a gift of the retirement account once taxes have been paid on the pre-tax IRA account. If we are looking at using an IRA Medicaid compliant annuity to create additional income and fund the Medicaid compliant annuity, clients would have two different options to fund the MCA. We could either do a direct trustee to trustee transfer, where the two custodians would interact with one another to transfer the money directly from the IRA custodian where the client has their current IRA over to the insurance company that's going to issue the IRA Medicaid compliant annuity. That transaction would take place between the two custodians, and the client would never actually receive a distribution of the IRA funds, they would never actually touch those monies before they go on to the IRA MCA custodian. The second option would be to do a 60-day rollover where the client would be contacting the current IRA Medicaid, the current IRA custodian and requesting a full liquidation without having any taxes withheld. And then within 60 days of receiving that distribution check, they would need to reinvest the money with the Medicaid compliant annuity insurance company in order for that to be considered a non-taxable transaction, as long as that would be done within a 60-day time frame, and as long as we are only dealing with one qualified account and there's not multiple IRAs, then it would be feasible to do the 60-day rollover instead of the direct trustee to trustee transfer. And really deciding on which of these options to use in order to fund the Medicaid compliant annuity comes down to the timing of getting all of this done. Usually the 60-day rollover will occur quicker than a trustee to trustee transfer. So if we're dealing with a client that's trying to get this type of planning done at the end of the month, the 60-day rollover is likely going to be a quicker option than relying on the trustee to trustee transfer in order for the current IRA custodian to transfer the money to the insurance company that's going to issue the Medicaid compliant annuity. If we use the retirement account to purchase an IRA Medicaid compliant annuity, either by a trustee to trustee transfer or the 60-day rollover, the IRA Medicaid compliant annuity is going to create additional income to pay through the penalty period. And that is as the annuity makes payments from the Medicaid compliant annuity contract, that is going to be considered fully taxable income as the annuity is making payments. So if we're dealing with a very short penalty period, let's just say a 6-month penalty period, and all of the annuity payments are going to be made in the same tax year. For example, in 2023, if we were the IRA Medicaid compliant annuity to start paying in May, and the client is going to receive all of their payments from that contract to cover a 6-month penalty, then all of that income is going to be considered taxable in 1 year anyways. So it may not make sense in that case to do the IRA Medicaid compliant annuity, and the client could simply just liquidate that IRA and use the after-tax dollars to implement the Medicaid compliant annuity. So really deciding on whether we want to use an IRA Medicaid compliant annuity or a non-IRA Medicaid compliant annuity is going to come down to the payout time frame of the annuity and how long the penalty period is. If we are going to extend over multiple tax years, then it's going to make sense to use the IRA Medicaid compliant annuity to pay through that penalty period. But if it's all going to be paid out in 1 year, then we can simply liquidate the IRA and use after-tax dollars to purchase the annuity, because the end result is going to be the same. Mark, did you have anything to add on IRAs or qualified accounts that you run into with clients?
No, other than I was just thinking, Amber, depending, and maybe we pull the audience somehow, some way, but it just reminded me of a session we had done a while ago about the difference between IRA annuities and IRA funds, and what can be done with those compared to non-IRA annuities and those funds when it comes to Medicaid compliant annuities. So because it's varied and it's different. So
And actually, Mark, I do have a question here from somebody somewhat related to real estate, if you have a chance to answer this. The question is, if you have stock that is closely held, stock in a closely held corporation, does listing it for sale make it unavailable, or how about taking a loan against it?
yeah. So Yeah, so if you really get into this area of law, elder law, or Medicaid eligibility, a couple practical suggestions that I have. One is, um, you know, every state has, administers its own Medicaid program. And what that really means is that is as long as the administration of the program is somewhat reasonable within the confines of what federal law has set forth, the states have quite a bit of latitude. So the way Wisconsin administers its Medicaid program is going to be different than Texas, and Texas is going to be different than Florida. So it really behooves you to get to understand the way your state is going to treat all this stuff. And also, if you can do it, if you do, if you do enough of this, we help in our office almost daily. We're helping clients apply for Medicaid. And if you can get a good working relationship with Medicaid offices and caseworkers in your state, you're really going to have insider information, if you will, about how to get things done for your clients that your state Medicaid offices and caseworkers are going to say, okay, this person's above board. They're not trying to break the rules. They're trying to follow the rules, help their clients follow the rules. And we don't, if we're going to second guess this application, we're going to second guess it in favor of of your client, because this is the attorney who's helping this client. And getting that relationship is extremely positive in terms of your ability to help your clients. And where I'm going with all of that as it relates to this question of, what we've got closely held stock is, how is your, if you say, look, we're going to try to sell it. We are really going to try to sell it. Okay, great. What is your state's Medicaid office and the caseworker going to do? Are they going to say, we don't care? Well, if you know that, then you know that we're going to get it sold. The opportunity that exists at that point is maybe then you establish a really good working relationship with a business valuation and appraiser, because if the business is worth $1 million and your client owns 10% of it, that's $100,000. But is it? I mean, who really is going to pay $100,000 for this 10%? So if you can go get an appraisal, maybe they'll say, in our opinion, it's worth 60,000. Well, then maybe a family member can buy it for 60,000 because that's its fair market value as determined by appraisal. So there's all these different things that you really want to be looking at, and how are they going to treat certain things in your state? Because, as we mentioned earlier, the nursing home's not going to take payment with X number of shares of closely held corporation stock. That's not, they need cash. And so, an argument that at least flies in Wisconsin is this notion of unavailability. And, if we're actively trying to sell and we're not able to sell it and liquidate it to cash within 30 days, it's unavailable. And that's in our state's Medicaid eligibility handbook, which, it's all worthwhile to go to your state and see what it says about availability and see if you could fall within those parameters.
Okay, perfect. It doesn't look like we have any other questions yet, so I'll move on to non-qualified annuities that clients own. With non-qualified annuities or annuities that are not purchased with IRA dollars, we would have the option to either exchange or transfer a non-qualified annuity into a non-qualified Medicaid compliant contract. We could also consider gifting the non-qualified annuity. And then finally, another option would be to liquidate the non-qualified annuity. With deferred annuities being a lump sum of cash or a lump sum of money that can be liquidated, we can exchange a deferred annuity for another type of annuity like a Medicaid compliant contract. When we have a deferred annuity that has significant growth, a contract that may have been purchased several years ago that has grown significantly in value, then the owner may consider a 1035 tax-free exchange in order to spread out the tax consequences of purchasing a non-qualified Medicaid compliant annuity by doing the 1035 exchange of the existing contract. A 1035 exchange is a provision in the tax code that will allow a policy owner to transfer money from an existing non-qualified annuity or life insurance contract into a new policy without having to pay taxes on the distribution. A 1035 exchange must occur between products that are like to like, and also the owner must be a like to like transaction or a like to like change between one owner to another. So if we have an existing life insurance policy, we can transfer that into another life insurance policy. A non-qualified annuity can be exchanged for another non-qualified annuity. And then finally, a life insurance policy can be exchanged for a non-qualified annuity. It is important to note that if the client has an existing non-qualified annuity that has surrender charges or early withdrawal charges, a 1035 exchange is not going to avoid these charges. It's simply going to transfer the cash value or the net value, net of surrender charges, over to the new insurance company that would issue the Medicaid compliant annuity, but we're not avoiding the early withdrawal charges or surrender charges by doing a 1035 exchange. If we use the 1035 exchange to purchase a non-qualified Medicaid compliant annuity, the non-qualified Medicaid compliant annuity is going to create additional income to help the client pay through a penalty period. And we're able to spread out the tax consequences of the existing non-qualified annuity by using a 1035 exchange in order to purchase the non-qualified Medicaid compliant annuity to pay through the private pay period or the penalty period for Medicaid qualification purposes. Also, we could consider gifting a non-qualified annuity. In order to gift the non-qualified annuity, we would need to contact the existing insurance company to request a change of ownership form. The change of ownership from the non-qualified annuity into a trust or outright to individuals would be considered a gift or a transfer for Medicaid qualification purposes. But a lot of times, if we are transferring ownership of an existing non-qualified annuity into an irrevocable trust, if that trust has the same social security number or is using the same social security number as the Medicaid applicants, then it would not be considered a taxable event to gift into that trust. But I do usually recommend obtaining confirmation from the existing insurance company that that change of ownership is not going to trigger a 1099 if you do gift the non-qualified annuity into a trust.
I'll just add something there, Amber, if that's all right.
Yes.
we've transferred these non-qualified annuities to trusts. And one other thing I'll mention, it's helpful to make sure that the trust is a grantor trust for income tax purposes. And then, as Amber mentioned on her last bullet point on the last slide, what we do in our office is when we send in or submit the transfer of ownership or change of ownership paperwork, we have a form letter that goes with that. And the form letter tells them to process the change of ownership request if they are not going to treat it as a taxable event and not generate a 1099-R. But if they are going to treat it as a taxable event and generate a 1099-R, then they are not authorized to process the transfer request. And we ask them to contact us so that we can talk our way through it before we create a tax liability for our client.
Perfect. Thank you, Mark. Then the last option with a non-qualified annuity would be to liquidate the annuity and use the proceeds to implement the gift-in annuity strategy. Because a deferred annuity is a lump sum of cash, the annuity owner would be able to contact the existing insurance company that issued the contract to surrender the policy. Upon surrendering the contract, then the owner is going to receive the cash settlement amount. This may or may not be, the proceeds may or may not have early withdrawal or early surrender charges associated to the amount that is received. It's going to depend on how long ago the annuity was purchased and whether there are surrender charges. Usually the charges are going to range anywhere from 15% if it's an annuity that was purchased recently, down to 0% if it's an annuity that was purchased years ago that no longer has any early withdrawal or surrender charges associated to it. And then now we're going to move on to life insurance policies that have cash value. So this is going to be non-term policies, so whole life insurance or universal life insurance that would be considered an available asset for Medicaid qualification. With life insurance, we would have the same options as we had available under the non-qualified annuities. We can either transfer into a non-qualified Medicaid compliant annuity using a 1035 exchange. We can consider gifting the life insurance or liquidating the life insurance. A life insurance policy can be converted into a Medicaid compliant annuity using a 1035 exchange. When we use the 1035 exchange in order to fund the Medicaid compliant annuity, this is going to create additional income to pay through the penalty period associated to making a gift. It's important when we are dealing with life insurance policies to figure out the difference in the policy's cash value versus the face value or the death benefit. Medicaid, for qualification purposes, is going to look at the cash value in a life insurance policy. If there is a large difference between the cash value and the death benefit, we may want to gift the policy in order to preserve the death benefit that would be paid upon the Medicaid applicant passing away. So if it's a situation where it's a policy that has maybe $10,000 in cash value, but it has a $75,000 or $100,000 death benefit that's going to be paid to the intended beneficiaries when the Medicaid applicant passes, we would be most likely looking at gifting or transferring the cash value of $10,000 and incurring the penalty period associated with gifting the cash value and letting that policy remain intact in order for the death benefit to be paid upon the insured passing away. Another option would be to liquidate the life insurance policy if there is not a large difference between the cash value and the death benefit on a life insurance policy. It may make sense just from a liquidity standpoint to liquidate the life insurance policy and use the proceeds in order to purchase the annuity and also to make a gift. So in this case, if the client does have a permanent type of life insurance policy that has cash value, they can contact the insurance company who issued the policy to surrender the contract, and they would then receive a lump sum of money or the cash settlement amount in order to implement the gift and annuity strategy.
One thing I'll add for all the note takers is for the life insurance in the case like where Amber mentioned, if the cash value is lower and the death benefit is higher, you do want to, if you can, preserve that type of policy because the death benefit being so valuable. One other option to look at too is whether a family member would be able to purchase that policy, because for Medicaid, if you do Amber's example, if it's got a $10,000 cash value with a $75,000 death benefit, Medicaid's going to value that policy as $10,000 because that's what the client could get to pay for nursing home. That's what's available. That's what is available. So for Medicaid, it's worth $10,000. So if somebody pays the client $10,000, then the client's going to stay as the insured, but the owner is going to become the buyer. And you have to be mindful of the transfer for value rules with life insurance, and that's a whole separate program. But be mindful of that, because $10,000 of cash that comes to the client, that can also be used for a Medicaid compliant and annuity. So it's just something to think about. If you can't gift it, but you don't want to lose it, maybe somebody can purchase it.
Okay, perfect. And Mark, did you want to cover this last section, the other illiquid assets such as real estate investment trusts and things like that?
Yeah, so this kind of comes close to the question that was asked earlier about the closely held stock. And I think a starting point for an asset like that is availability, right? I mean, and who wants it? How if you have Apple computer stock, that is very, 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 very easy to turn around and get cash. It's not as liquid as cash, but it's pretty darn close. Apple computer stock is practically cash. But some of the investments that our clients can have, closely held securities, REITs, alternative investments that do not become liquid until a date certain, until there's a liquidation event. Certainly one avenue that we're going to want to look at as Medicaid eligibility attorneys is unavailability. Look, I don't have the ability right now to take this asset and get cash for it. The nursing home wants cash. The assisted living facility wants cash, and I'm unable to generate it right now because these are the terms tied to these particular assets. So unavailability is something you're going to want to look at. For anything where you take the position of unavailability, and this is maybe something that Amber can help you with, A Medicaid agency will say, okay, maybe it's unavailable in dealing with the issuer of that particular asset, but could you sell this asset to somebody and get somebody else and get cash that way? And so, a lot of times, where I would say Amber and I are really familiar with this because it's been done in Wisconsin for a very long time. There could be an annuity that your client has that's in an annuitized annuity where it's paying out. And there's nothing else that the client can do. It is stuck in payout mode. Okay, but the question a Medicaid agency may ask is, well, will somebody buy that stream of payments from you? And if the answer is yes, then you need to sell it to that buyer and get cash. So this would go for a promissory note. If a client loaned money to their child, documented by even a promissory note document, signed and properly executed, that's a right to receive money from that child. But can that right to receive money be sold on the will somebody buy it? And what you need to do if you're going to play the unavailability game is you may have to go out to the secondary market and get letters from them saying, thanks for offering this to us, but we're not interested. You might have to prove that there is no market for it. So just a couple, illiquid assets are tough. There's no question about it. But from a Medicaid eligibility standpoint, you always want to be mindful of the availability of assets law in your state and how it works. And if you can't get the money from it and you're unable to sell whatever it is to somebody and you can prove that, then it won't be treated as a counted asset until or an available asset until the liquidation event occurs or something occurs in the future when you can actually do something about it.
Okay, perfect. So really, in talking about all of these different assets, we kind of wanted to summarize and give you just a summary on the whole point of the talking about these types of assets is to think about gifting or transferring any of the illiquid assets and using cash to purchase the annuity to pay through the penalty period. Because an insurance company that is issuing a Medicaid compliant annuity is going to need actual cash or a wire transfer or cash value from an existing life insurance or annuity policy in order to purchase the annuity, we really need cash assets in order to purchase the annuity, and any illiquid assets that cannot be liquidated easily can be considered part of the gift or the transferred amount. Last time we talked about the different bucket method when we're talking about an individual client that is applying for Medicaid, and in most states the client is only able to keep around $2,000 of liquid assets in their name, and the remaining amount would need to either be gifted or used to purchase the Medicaid compliant annuity in order to get that individual resource and income eligible for Medicaid in order to start a penalty period. And I know we're running up on the very last minute here, but if anybody has any questions on today's program, feel free to type those in now. Otherwise, you can find both of our contact information, myself and Mark's information on the screen here. Feel free to reach out to us either by phone or email with any questions that you have. Mark, did you have anything to add? I'm not seeing any questions that have not been answered yet, but if you have anything to add, just let me know.
Yep, nothing to add, but I'll stick around in case some questions come in when we conclude.
Okay. Okay, yeah, I'm not seeing any yet, but like I said, thank you for joining us today. Thank you, Mark, for your time. And if anybody has any questions about today's webinar, feel free to reach out either by phone or email. Thank you, everybody. And if you're going to be in Puerto Rico next week, enjoy the sunshine.
Thanks, everyone. Thank you, Amber.
Thank you. Take care.